what got dismissed? Hey, let's go, let's go. Hey, let's go, let's go. What got dismissed? What up, gang? What's poppin'? Yo, Ash, what up? Boars, Taretha, what up? Noah, Regal, what up? Hit that like button on the way in, man. I appreciate you. What up? Hey, yo, man, it's a crazy day, bro. T-Ski, what up? It is, bro. I'm not even on Twitter like that, bro. I tell y'all that all the time. I'm not even on Twitter like that yesterday. I posted a little something yesterday. We were actually live. Koala, my boy, la. What up? What got dismissed? Hey, let's go, let's go. Hey, yo, the whole of hip hop, is doing backflips and celebrating right now. That's got to tell you something, bro. That's got to tell you something. Niggas was not having it, bro. I don't care. Listen, they spinning the narrative. At least they trying to. They trying to spin a narrative and say, y'all are with the machine. The machine want. Niggas, stop playing with us, bro. It's hip hop over everything at this point. It's a great day, gang. It's a great day. Let's go. It's a great day. It's a great day. It's a great. Now listen. Shout out to my dog Koala in the chat. W Koala in the chat, man. W Koala in the chat if y'all seeing me here, man. We were live yesterday, fam. We were live yesterday as the news broke, okay? And at that time, dog, even you, myself, we was searching, looking for the documents. Couldn't find anything at the time. It was so fresh. And at the time, Absa was the only person that had it, man. So I absolutely did not want to snipe her stream or nothing like that. That is what she does. That is literally what she does, bro. So she went ahead and did that. I seen a lot of people getting on yesterday. Hey, shout out Hoodie, my dog, for the 2. W Hoodie in the chat. Yeah, W Koala. What a time to be alive, man. What up, Deontay? Shout out to everybody for pulling up. Make sure y'all hit that like button and subscribe. Listen, I have not had an opportunity to look at any of this. All I have seen is the aftermath. All I have seen is the excitement, the happiness around the fact that freedom of speech, the freedom of speech has been emboldened in a sense where we're not going to allow people to just sue you for speaking your mind. That's not what this is. That is not what this is, bro. And then also it seems like he's about to try to appeal. Like, what did this take? Hold your L. Hold your L. What are you doing? Hold it. Relax. What up? It's gonna be an amazing weekend celebrating Not Like Us winning. Yeah, bro. Not Like Us all weekend. I was at the gym this morning. It came on while I was in the gym, bro. I damn near dropped the weights. I damn near dropped the weights. I damn near dropped the weights, bro. Appreciate it, everybody. We love the crew. No, we love you, bro. We love you too, man. Always, always, always. So like I said, man, I have not gone through any of this. I'm super excited to see what this judge said. This judge seems like she's had an understanding of battle rap or rap at some point, because the way that she had been previously discussing the case, she seemed like she was down, bro. She seemed like she was down. Hey, shout out to Michaela. Shout out to Michaela. Shout out to everybody pulling up. All right, we got 38 pages to get to. I think most of this is new too, bro. I think most of this is new. Some of y'all have heard it already, so I appreciate y'all for rocking with your boy. Hey, yo! Latrice with the 50. Let's go. Shout out my dog. Shout out my dog Latrice with the $50 donation. I appreciate you. It's getting spooky every day in October. You already know, man. October. It's spooky season. Thank you so much. W Latrice in the chat if you guys do not mind. W Latrice in the chat. Anytime we get a dono, man, we want to make sure we W them because they don't have to support the channel, but they do. And we really appreciate everything, man. We appreciate everything. All right, we got 38 pages to get into. Y'all know I'm ready to go ahead and lock in and get this done. I'm excited to read this, and then we got another video to react to right after that, which is basically we talking about the boy is already talking about appealing. Now, there is a poll that I listed up top, right? There's a poll up here. Make sure you guys are answering this poll. 90% of y'all already saying, hell no. Will Drake be successful in his appeal? I should have had a question mark after that. You know, I'd be moving too fast sometimes. Will Drake be successful in his appeal? Hell no. Yeah, I think so. Maybe. Look, we got some of y'all hiding in here too. Hold up. We got some of y'all hiding in here too. I see y'all say, yeah, I think so. 4%? 4%? Who said it? Let me know in the chat. Who said it? Who said it? Wagwan, what up, Slay Queen? Noah, what up? All right, let's go ahead and get into this. Let me get some water. Should I put my glasses on for this? I can't even find my glasses. Okay. Jeanette A. Vargas, United States District Judge. This case arises perhaps from the most infamous rap battle in genre's history, the vitriolic war of words that erupted between superstar recording artist Aubrey Drake, and Kendrick Lamar Duckworth. Lamar or Kendrick Lamar? Okay. In the spring of 2024, over the course of 16 days, two artists released 8 so-called diss tracks with increasingly heated rhetoric, loaded accusations, and violent imagery. The penultimate song of this feud, Not Like Us by Kendrick Lamar, dealt the metaphorical killing blow. See, cooking! Okay, I'm not gonna do this the whole time. I swear, I ain't gonna do this. I ain't gonna do this the whole time, bro. I ain't gonna do this the whole time. It's just exciting. I ain't gonna do this the whole time. This is insanity. This is insanity. This is insanity. Monroe, what up? All right. The penultimate song of this feud, Not Like Us by Kendrick Lamar, dealt the metaphorical killing blow. The song contains lyrics explicitly accusing Drake of being a PDF, set to a catchy beat and propulsive bass line. Not Like Us went on to become a cultural sensation, achieving immense commercial success and critical acclaim. Both Drake and Kendrick Lamar have recorded contracts with defendant UMG Recordings, Inc. Drake alleges that UMG intentionally published and promoted Not Like Us while knowing that the song's insinuations that he has a sexual relation with minors were false and defamatory. They dismissed it. It's gone. They dismissed it. Drake has brought this action against UMG for defamation, harassment in the second degree. Hey, yo, is it Hannah Color? Hannah Color. Shout out to Hannah Color for becoming a Crew Access member. Thank you for becoming a member, gang. I appreciate you. Drake has brought this action against UMG for defamation, harassment in the second degree in violation of Section 349 of the New York General Business Law. Before the court is a defendant's motion to dismiss pursuant to Rule 126B6 of the Federal Rule of Civil Procedure. Because the court concludes that the allegedly defamatory statements in Not Like Us are non-actionable opinion, the motion to dismiss is granted. I need 1 second applauses. I need 1 second applauses from the company man throughout this whole thing. Legal standards. To survive a motion to dismiss, a complaint must contain sufficient factual matter accepted as true to state a claim of relief that is plausible on face. Hey, yo, shout out to Chris and Tasha. It's a beautiful day for hip-hop. Hip-hop, hip-hop. For the 10W, Chris and Tasha in the chat, I appreciate you. Hey, where's Renee? Hope everything is okay. Yeah, I hope everything is okay. We have not seen Renee in quite some time. I hope everything is okay, though. A plaintiff may not simply allege facts that are consistent with liability. The complaint must nudge plaintiffs' claims across the line from conceivable to plausible. Threadbare recitals of the element of a cause of action supported by mere conclusatory statements do not suffice. It's not going to work. We're not allowing that, okay? When ruling on a motion to dismiss under Rule 126B6, the court accepts as true all well-pleaded allegations and draws all reasonable inferences in favor of the non-moving party, okay? The court need not credit legal conclusion couched as factual allegations. However, the court may also consider documents incorporated in the complaint by reference and matters of which judicial notice may be taken. And we're citing cases here, so that's the only reason why we're not reading those. Judicial notice is appropriate when a matter is not subject to reasonable dispute because it, is generally known within the trial court's territorial jurisdiction, or can be accurately and readily determined from sources whose accuracy cannot reasonably be questioned. Now, I remember the lawyers in the chat being like, I can't believe y'all get excited to read this stuff. It's amazing to me. It's amazing. It's fun at this point. Now, if I had to read hundreds of pages of this, I probably wouldn't be as excited about it. But shout out to all the lawyers in the chat too, because I know some of y'all is in here, man. They tried to make a case using Twitter and YouTube comments. I can't even understand how that's possible, but they did. They tried to do it. Background. The following bro, I have my neighbor across the street, bro. Their alarm just randomly goes off at random times throughout the day, bro. 4 or 5 a.m. Yo, I knocked on their door at 5 a.m. 3 nights ago. 3 nights ago. No shirt, just went over there. What's up? Do I got a case? Can I call some people? Let me know, bro. Let me know. J2, what up? The following background is largely taken from the allegations in the amended complaint, which are assumed true for purposes of this motion. Additionally, defendant requests the court to take judicial notice of certain extrinsic evidence pursuant to Rule 201 of the Federal Rules of Evidence. These exhibits include the lyrics of the song released as a part of Drake and Kendrick Lamar's rap battle. The dates on which these songs were released and the lyrics of these songs are not reasonably subject to dispute. And the songs themselves are, with one exception, all referenced in the amended complaint. Which one was it? Was it Tailor-Made Freestyle? Was it Tailor-Made Freestyle that they took out? I think that's what it was. And the songs themselves, with one exception, are all referenced in the amended complaint. Accordingly, the court will take judicial notice of exhibits H through I and exhibits K through O to request for judicial notice to understand the defendant's alleged statements in their necessary and proper context. Judicial notice of submissions that place the defendant's comments in the broader social context to aid the court's determination of the adequacy of plaintiff's defamation claims. Exhibits B, J, and P are directly referenced and relied upon in plaintiff's amended complaint. So those documents are likewise properly before the court. And because the document can be accurately and readily determined from sources whose accuracy cannot reasonably be questioned, the court also takes judicial notice of the search results from the New York Times website and Exhibit C. The court takes judicial notice of the existence of the listed articles, but not the truth of their context. Hold up. Is that what we saying? Furry B, what up? Okay, we know that they there, but we can't really look at the truth of the contents, okay? Taking judicial notice of 4 websites on motion to dismiss because courts in this circuit generally have the discretion to take judicial notice of internet material, okay? It is generally proper to take judicial notice of articles and websites published on the internet. A, factual allegations. Drake is a prominent recording artist and songwriter among other public-facing endeavors. Drake has had a successful music career. Here's a footnote. During oral argument, plaintiff agreed that these exhibits were properly before the court in its consideration of the motion to dismiss. Under defendant UMG for at least 20 years, UMG uses its brands and imprints or labels to provide its music artists with the means to create, promote, and distribute their music commercially. Defendant through Universal Music Publishing Group holds exclusive publishing and distribution rights to Drake's music, as well as that of artist Kendrick Lamar. So they both of them. We own the publishing to both of them, so I'm not really understanding this, right? I had a neighbor who was constantly up playing trash music, so I borrowed my dad's chainsaw, covered it in ketchup. What? Chris and Tasha for the $20 no. Been streaming Not Like Us a lot today for the culture. Shout out to Chris and Tasha. Chris and Tasha in the chat. On April 19, 2024, Drake released a diss track directed at Kendrick Lamar called Push-Ups. In Push-Ups, Drake mocks Lamar's height and shoe size. How the F you big stepping with a size 7 men's on and pipsqueak pipe down, and questions Lamar's success. You ain't in no big 3. I'm at the top of the mountain, so you tight now. Just to have this talk with your ass, I had to hike down. A few days later, Drake released Tailor-Made Freestyle, in which he used artificial intelligence generated voices of deceased rapper Tupac and of rapper Snoop Dogg to goad Lamar. In the track, Tupac and Snoop Dogg share their disappointment that Lamar had not yet responded to push-ups. Kendrick, we need you. The West Coast savior. You seem a little nervous about all of the publicity. Did that even matter? What? You gotta show this effing owl who the boss on the West. Drake in his own voice further taunts Kendrick for failing to come up with a satisfactory response, saying, I know you're in that New York apartment. You struggling right now. I know it. In the notepad during lyrical gymnastics, my boy. The footnote says, Drake's clothing brand is October's Very Own, or OVO, which is represented by an owl. Shout out to Wendy! For the $5 dono, yesterday, people were outside the Compton courthouse blasting Not Like Us Celebrate. Bro, I could only imagine if I lived in Cali, what it would be like on the streets out there. I could only imagine. We got to see some TikToks of them doing that too. W Wendy in the chat. Also surmises that Kendrick was purposefully delaying his response because artist Taylor Swift had just released a new album. Shout out to Taylor Swift, the biggest gangster in the music game right now. She got the whole PG Lang on mute like that Beyonce challenge. Y'all boys quiet for the weekend. Lamar fired back at Drake in Euphoria, which was released on April 30th, 2024. In the track, Lamar claims, I make music that electrify him. You make music that pacify him. And that he would spare Drake at this time. That's random acts of kindness. He accuses Drake of fabricating his claims. Know you a master manipulator and a habitual liar too. But don't tell no lie about me, and I won't tell truths about you. Dun, 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 shit. He insults Drake's fashion sense. I hate the way you walk, the way that you talk. I hate the way that you dress. Further raps, I believe you don't like women. It's real competition. You might pop ass with them. And taunts Drake for being a coward with his responses. I hate the way that you sneak this. If I catch flight, it's going to be direct. On May 3rd, 2024, the feud between Drake and Lamar escalated as they lobbed increasingly vicious personal accusations at each other over the course of the day. First, Lamar released 616 in LA at 3, in which he calls Drake a terrible person, playing dirty with the propaganda and raps that if Drake was street smart, then he would have caught on that his entourage is only there to hustle him. Drake's next response arrived later that day in Family Matters. Drake jabs at Lamar's relationship with his partner. You the black messiah wifing up a mixed queen and hit vanilla cream to help out with your self-esteem. On some Bobby I want to know what Whitney need. And it implies that Lamar physically abused her. You a dog and you know it. You just play sweet. Your baby mama captions always screaming, save me. You did her dirty all your life. You're trying to make peace. Moreover, Drake calls into question whether Lamar is the biological father of one of his children. My God. Hold on. One time. Come on, bro. We can't do this right now. We can't do this right now. We gotta have all of the we gotta have them all, bro.
Down bad, you suffering.
Yeah. One time. Down bad. One more time.
Down bad, you suffering.
One more time.
Down bad, you suffering.
All right. Almost immediately after the release of Family Matters, Lamar unleashed the scathing Meet the Grams at 3, in which he accuses Drake of being a deadbeat father and of hiding the existence of the other children. You lied about your son. You lied about your daughter, huh? You lied about them other kids that's out here hoping that you come. Lamar also alleges that Drake has a gambling problem, drinking problems, pill popping and spending problems, bad with money, whorehouse, soliciting women problems. Therapy's a lovely start. He further insinuates that Drake was a predator and that Drake should unalive. So all these women can live with a purpose. The next day on May 4th, 2024, Lamar released Not Like Us. Damn, it was really, you know what I'm saying? I kind of feel like Terry Ann with the 5 Crew membership. Shout out Terry Ann, W Terry Ann in the chat for the gifted 5. If you got one, say thank you. Thank you so much. A lot of times I don't really think that it was happening just like that, bro. Within 2 weeks, we got all of these songs. Day after day, sometimes 2 times in a day. We was really turned up back then. Really turned up. Specifically, the track contains the following lyrics. Wait, the next day on May 4th, Lamar released Not Like Us. Not Like Us explicitly names Drake and his associates as PDFs. Specifically, the track contains the following lyrics. Say, Drake, I hear you like I'm young. You better not never go to cell block 1. To any of it to talk to him in love, just make sure you hide your little sister from him. They tell me Chubb's the only one that get your hand-me-downs. And party at the party playing with his nose now. And Baka got a weird case. Why is he around? Certified lover boy, certified. Wop. Dot them up. Wop. I'ma do my stuff. Hey, look. This is comedy, bro. This is too much fun. It shouldn't be this much fun. It shouldn't be this much fun. Why you trolling like a, ain't you tired? Trying to strike a chord and it's probably A minor. On May 5th, 2025, Drake responded in the Hard Part 6, directly denying Lamar's allegations of PDF. I never been with no one underage. But now I understand why that's the angle that you really mess with. Just for clarity, I feel disgusted. I'm too respected. If I was effing young girls, I promise I would have been arrested. Oh my, that is the worst way to rebut somebody calling you a PDF. Not that just because I wouldn't do it because I'm just not a creep, but I would have been called if I was doing this. Are you sick? If I was doing this. Disgusting. Drake is not a name that you're going to see on no sex offender list, okay? In the track, Drake further sneers at this Epstein angle, was the shit I expected, and accused Lamar of wanting to misdirect. Drake also alleges that he had planted some of the information Lamar used against him. We plotted for a week and then we fed you the information, but you so thirsty, you not concerned with investigation. You got to learn to fact check things and be less impatient, okay? Chubbs, Party, and Baka are associates of Drake, while K-Dot is a nickname for Kendrick Lamar. What? Wait. Chubbs, Party, and Baka are associates of Drake, while K-Dot is a nickname. They had to specify that? Okay, cool. I bet. I see you. Not Like Us was a huge commercial success. It has gained immense popularity on streaming and social media platforms, and it has been streamed globally more than 1.4 billion times on Spotify alone as of April 2025. I wonder where those numbers are now. Yeah, I wonder where those numbers are now. On November 8, 2024, the Recording Academy nominated Not Like Us for several Grammy Awards. And in February 2025, it won Record of the Year. A week later, on February 9, 2025, Kendrick Lamar performed Not Like Us live during the Apple Music Super Bowl LIX halftime show. The performance is alleged to be the most watched Super Bowl halftime show of all time, with over 133.5 million views. What? You said plus Canada doesn't have a registry? That's nasty work. That's nasty work. Procedural history. Plaintiff brings claims for defamation, harassment in the second degree in violation of New York General Business Law, Section 349, based upon UMG's publication and promotion of Not Like Us, the recording. Defendant has filed a motion to dismiss the amended complaint. On June 30th, 2025, the court heard oral argument from both parties concerning the motion to dismiss and the request for judicial notice. Plaintiff contends that he was defamed when defendant decided to publish, promote, exploit, and monetize allegations that it understood were not only false, but dangerous. So Tim, again, I feel like common sense just ain't so common. Common sense just ain't so common. And the thing is, and I think Koala said it right. Where you at? You still in here, Koala? Are you still in? I think Koala said it right, bro. They just draining his bank account. It's no way that they didn't know that bro dropped diss records doing exactly the same damn thing. And then say, you know what, man, that is factually false. It's not true. It didn't happen. But then for him to go on to do the same damn thing, how does that make sense? That is crazy. They got to be just draining bro's bank account. They know they was going to lose. They knew they was going to lose. Drake accuses Drake of engaging in criminal acts, including PDF and other acts that would require registering as a S offender and of being a registered S offender. The amended complaint alleges that the song implies that Lamar has heard. Shout out to Giovanni, albeit from undisclosed sources and concerning undisclosed individuals, that Drake has a predilection for underage women. According to the amended complaint, the reference to Cell Block 1 is a thinly veiled threat that Drake should be careful that he never ends up in prison, a place where child predators are notoriously the target of violence. The line Certified Lover Boy Certified PDF is a perverse reference to Drake's 2021 album Certified Lover Boy. Plaintiff argues that the use of the term certified communicates that Drake has been found to be a PDF. It is absolute insanity how a rapper can't see that it's wordplay. It's word, but you know, he studies rap battles for a living. Studies rap battles for a living. I study rap battles for a living. I study rap battles for a living. That's what I do. And the final line of his passage plays on the dual meaning of minor, a person under the age of 18, and a musical scale. Plaintiff further cites as defamatory the recording descriptions of Drake as Malibu's most wanted and a predator, and that his name got to be registered and placed on Neighborhood Watch. The associated music video shows images associated with S trafficking to reinforce the PDF accusation. The recording is also accompanied by an album image of Drake's home in Toronto, which is plastered in icons used by law enforcement and public safety applications to denote the residences of registered S offenders. I remember seeing that for the first time and being like, yo, this is not the angle we doing right now. What? We putting this house out there? Genius. Discussion, the defamation claims. Under New York law, the elements of a defamation claim are 1, defamatory statements of fact, 2, regarding the plaintiff, 3, published to a third party, 4, that is false, 5, made with applicable level of fault, 6, causing injury, and 7, not protected by privilege. Shout out to Kit Kat, I appreciate you. A defamatory statement is one that exposes an individual to public hatred, shame. Whoa, this is a word I've never seen before. Obliquy? Oh, I'm looking this up. Y'all know how we do over here, bro. We pride ourselves on understanding at least some parts of the English language, you know. How do you say this?
Obliquy.
Obliquy. What?
Obliquy.
Use it in a sentence.
Obliquy.
Strong public criticism or verbal abuse is obliquy. Oh, I'm using that. Strong public criticism or verbal abuse. You can't just... No, I can't say it like that. Yeah. That's crazy. I've never heard of that. Contumely, odium, contempt, ridicule, aversion, ostracism, degradation, or disgrace, or induces an evil opinion of one in the minds of right-thinking persons and deprives one of confidence and friendly intercourse in society. The issue in this case is whether Not Like Us can reasonably be understood to convey as a factual matter that Drake is a PDF or that he has engaged in sexual relations. Leonardo! With the big $50 donation. Shout out to Leonardo, man. W Leonardo in the chat. Thank you. I appreciate you. Y'all remember fake trading cards like Pokemon and Yu-Gi-Oh in the past? It's absolutely hilarious that you multi-window The Heart Part 6 from Aubrey's YouTube. Out of all other videos, Judge Vargas was picked up the document and was insulted. Shout out to Leonardo for the $50 donation. I appreciate you, fam. W Leo in the chat. Facts versus opinion. Okay? Under the First Amendment, there is no such thing as a false idea. Only assertions of facts are capable of being proven false. Oh, okay. I like that. Moreover, the New York Constitution provides for absolute protection of opinions. Okay? Absolute, the key word. The key word is absolute protection of opinions. Okay? These are not proven facts. These are just my thoughts. Shout out to Rob Markman. Thus, courts must distinguish between statements of fact, which may be defamatory, and expressions of opinion, which are not defamatory, and have the full protection of the New York Constitution. Whether a challenged statement is fact or opinion is a legal question. Plaintiff argues that it is inappropriate for the court to determine at the pleading stage whether a reasonable listener would perceive the recordings as fact or opinion. Yet, because this is a question of the law, New York courts routinely resolve this question at the motion dismiss stage. On a motion to dismiss, that challenge statement constitutes opinion. Shout out to Carney! 36 Maria! Look at those double plats. Shout out to my dog for the 36 Maria, my boy. Officially makes 3 years, man. Thank you so much for all your support, dog. Like Carney, been here since the beginning. Whether a statement is a fact or opinion is a question of law for the courts to be decided based on what the average person hearing or reading the communication would take it to mean, and is appropriately raised at the motion to dismiss. Holding that because whether a statement is defamatory presents a legal issue to be resolved by the court. Defamation actions are particularly suitable for resolution on a motion to dismiss. Let's read that again. Defamation actions are particularly suitable for resolution on a motion to dismiss. There is a particular value in resolving defamation claims at the pleading stage, so as not to protract litigation through the discovery and trial and thereby chill the exercise of constitutionally protected freedoms. In distinguishing between fact and opinion, 3 factors guide the court's consideration. Whether the specific language in issue has a precise meaning, which it readily understood. 2, whether the statements are capable of being proven true or false, and whether either the full context of the communication in which the statement appears or the broader social context and surrounding circumstances are such as to signal readers or listeners that what is being read or heard is likely opinion, not fact. Facts versus opinions. We got to understand the difference. The court conducts this inquiry through the lens of a reasonable listener. Okay? You and I, we are reasonable listeners and can understand that what was being said is obviously an opinion, not fact. Okay? Plaintiff's suit is focused on a single factual message conveyed by the recording. The false allegation that Drake is a PDF. The recording is myopically focused on ensuring that listeners take one message away from the song. Drake is a PDF. This statement has a readily understandable meaning and is capable of being proven true or false. But even accusations of criminal behavior are not actionable if, understood in context, they are opinion rather than fact. The alarm is going off again. The alarm is going off again. Thus, the court will focus its analysis on the third factor. This inquiry is a holistic one which looks to overall context in which the assertions were made. In order to assess the impact that the statements would have on a reasonable listener, context includes the forum in which the communication was published, the surrounding circumstances, the tone and language of the communication, and its apparent purpose. The forum. I take a sip. It's still going off, bro. It's literally still going off. I'm surprised y'all can't hear it. You can hear it? Just stopped. This is what I got to deal with. This is what I got to deal with. The court considers the form in which the allegedly defamatory statement appears, as that is a useful gauge for determining whether the reasonable reader will treat it more readily as opinion and fact. For example, the average listener is more likely to understand statements made in a news program or in a journalistic piece to be factual, while statements made in the opinion page of a newspaper or on an internet comment page are generally perceived as opinion. And they built a whole case on this. They built an entire case on this. Y'all can't hear it? Okay, I thought y'all heard it. It's loud, bro. It's loud. It's loud. It's very loud. Where am I at? The common expectation is that the column and articles published on the newspaper's op-ed section will represent the viewpoints of their authors and, as such, contain considerable hyperbole and speculation. So normal people listening to this are not expecting this to be some factually based song, bro. We all knew that already. It took them how long to figure this out? Diversified forms of expression and opinion. The culture of internet communications as distinct from that of print media such as newspapers and magazines has been characterized as encouraging a free-wheeling anything goes writing style. Okay? The fact that the allegedly defamatory statement appeared on Twitter conveys a strong signal to a reasonable reader that this was a defendant's opinion. The media vehicles used to decimate the alleged defamation, a WordPress blog, social media post, and an unsigned press release complaining about litigation tactics, suggest to readers that they contain opinions, not facts. And they are written in an amateurish fashion. The form in which a statement appears is not dispositive of the fact versus opinion inquiry, but it does provide contextual is that indica or indicia?
Indicia.
Indicia. It definitely ain't indica. It definitely ain't indica. It's indicia, okay? It definitely ain't indica. That's actually crazy that I said that. My bad, gang. The forum here is a music recording, in particular a rap diss track with accompanying video and album art. Diss tracks are much more akin to forums like YouTube and X, which encourage a freewheeling anything goes writing style than journalistic reporting. The average listener is not under the impression that a diss track is the product of a thoughtful or disinterested investigation, conveying to the public fact-checked, verifiable content surrounding circumstances. Next, the court considers the full context of the communication in which the statements appear, including the setting surrounding the communication. The fact that the recording was made in the midst of a rap battle is essential to assessing its impact on a reasonable listener. Even apparent statements of fact may assume the character of statements of opinion when made in public debate, heated labor dispute, or other circumstances in which an audience may anticipate the use of epithets, fiery rhetoric, or hyperbole. As context is key, defamatory statements advance during the course of a heated public debate, during which an audience would reasonably anticipate the use of epithets, fiery rhetoric, or hyperbole are not actionable. Okay? The decision by the New York Court of Appeals in Stein-Hilbers is intrusive in this regard. Okay, do we want to read all of that? Yeah, no, these are specific court cases. For example, in Euphoria, Lamar calls Drake a master manipulator and a habitual liar and a scam artist. Drake responds in Family Matters by heavily implying that Lamar is a domestic abuser. He also raps that he heard that one of Lamar's sons may not biologically be his. Why you never hold your son and tell him, say cheese. We could have let the kids out of this. Don't blame me. I heard that one of them little kids might be Dave Freeze. Okay? And Meet the Grams. Lamar takes issue with Drake involving his family members in their feud. Dear Aubrey, I know you're probably thinking I wanted to crash your party, but truthfully, I don't have a hating bone in my body. This is supposed to be a good exhibition within the game. But you effed up the moment you called out my family name. Hello to discredit some decent people. In that same track, Lamar alleges that Drake uses the weight loss drug Ozempic. Question. Wait, hold on real quick. I'm lagging. Hold up, gang. I'm actually not sure why we lagging like that. Yeah, I know. Give me 1 second. No. It's me. Yeah, I know. Give me a second. I'm trying to figure it out. Maybe that'll help. Let me see. Bro, we dropping frames like crazy, huh? Yeah, bro, ain't my neighbors messing with me? It's saying no data too. Hold up. Hold up. Are we back? What happened? Let me see. It's the Iceman. Bro, what is happening, bro? I'm still here, but I'm lagging like crazy. This is the craziest lag I think I had in like years, bro. Come on, bro. Is it the OVO? Is it OVO they sniping me? They trying to snipe me? You can't snipe me. Hold on. Let me try this. Give me if we cut off, I'm coming right back on. Hold up. Let me check this. Real quick. Bro, we still dropping mad frames. It's okay. It say excellent connection now. I don't know. It say excellent connection now, but it showed me dropping frames, bro. So I don't know. Yeah, it can't be excellent, bro. I'm dropping frames. I see it. Nah, they messing with me. Hold on. I'm gonna have to end the stream, bro. There's no way I can do the stream like this. There's no way I can do it like this. Are we coming back? It looks like we coming back. Are we better now? Yeah, it look like we coming back. Yeah, it look like we coming back. Okay. It's better. Hey, bro. What just happened, man? They still say I'm dropping frames, but it's not as bad. I'm gonna keep it going. If it stops, we'll have to figure it out. I got a message from Xfinity talking about they was finna, be doing some work. I just don't know if it was today or not. All right, I'm gonna try to cut that part out. On the playback. All right. The weight loss drug Ozempic. Don't cut them corners like your daddy did. F that Ozempic did. Don't pay to play with them Brazilians. Get a gym membership. Lamar also insinuates that Drake knowingly hires S-offenders. Grew facial hair because he understood being a beard just fit him better. He got S-offenders on the OVO, on HOVO that he kept on a monthly allowance. Of particular relevance, in tailor-made freestyle, Drake alleged Lamar to make PDF accusations at issue. Using the artificially generated voice of deceased rapper Tupac, Drake goads Lamar. Kendrick, we need... Okay, we read that already. It is in this context in which such lyrics as "Say Drake, I hear you like I'm young" from the recording must be assessed. The similarity in the wording suggests strongly that this line is a direct callback to Drake's lyrics in the prior song. Plaintiff argues that the court should ignore the songs that came before and assess Not Like Us as a singular entity. Plaintiff argues that the average listener is not someone who is familiar with every track released as a part of the rap battle. Wait, what? Plaintiff argues that the average listener is not someone who is familiar. Are you serious? This is what they tried to say? We was all glued to it. We knew exactly what was going on. Because the recording has received a level of cultural ubiquity far beyond the other 7 songs, plaintiff contends that the court should not consider those other tracks in assessing how the average listener of the recording would perceive the allegations regarding Drake. There are a number of flaws with this argument. Not Like Us cannot be viewed in isolation, but must be placed in its appropriate factual context. Statements must first be viewed in their context in order for courts to determine whether a reasonable person would view them as expressing or implying any fact. Here that factual context is the insults and trash talking that took place via these diss tracks in the days and weeks leading up to the publication of Not Like Us. The songs released during this rap battle are in dialogue with one another. They reference prior songs and then respond to insults and accusations made by the rival artists. The songs thus must be read together to fully assess how the general audience would perceive the statements in the recording. Holding that 2 newspaper articles, yeah, I remember that. Notably, the Second Circuit rejected a similar argument in Terrain. There, the plaintiff argued that the district court improperly considered the statements that he made during the War of Words because they were not included in his complaint. The Second Circuit held that because the court must look at the overall context in which a statement was made in order to determine if it is actionable, the district court properly considered all statements made during the feud between the disc jockeys, regardless of whether they were included in the complaint. Where we at? What happened? We had some issues, bro. It's not, now it's back. It looked like it's back. It's pissing me off, bro. I don't know what's going on. Yeah, I don't know what's going on. Chat, I'm gonna have to end the stream. I'm going to pick it up here in a minute. I'm going to have to end the stream. Come right back. Give me like 10 minutes. I have no idea what's going on. I love you guys. I'll see you in like 10 in a few minutes. I have to end the stream. My bad. I'm going to cut this out. I'll see y'all in a little bit.